Hello everyone and welcome back to our channel. This is Siddhi and you're watching me on For Women in India. Today's topic of discussion is the Shakti law introduced by the Maharashtra government in December 2020 to make changes in the existing laws on violence against women and children. The reason for proposing these new laws was the growing number of cases of violence and sexual violence against women and children. According to the 2019 NCRB report, Maharashtra ranked as third highest in cases of crimes against women, while Uttar Pradesh and Rajasthan comes on first and second position respectively. The state accounted for 9.2% of the total registered crime against women across the country. The bill states that in order to effectively control the heinous sexual offences against women and children, it is necessary to complete the investigation and trial of these cases within a short time frame, which may deter the perpetrators from committing such offences. It further says that stringent punishment, including heavy fines and death penalty, needs to be prescribed. Under the Shakti law, two bills have been proposed, namely the Maharashtra Shakti Criminal Law, Maharashtra Amendment Act 2020, and the Special Court and Machinery for Implementation of Maharashtra Shakti Criminal Law 2020. As per the second bill, establishment of exclusive special courts for speedy trials of crimes should take place. These courts shall take cognizance of the specified crimes. The person conducting the prosecution shall be deemed as public prosecutor, which will be appointed by the state government. The tenure of the special public prosecutor shall be for the duration of the trial of the concerned offence. The government would also like to establish institutions like trauma centers, one-stop centers, Sudhar Grah, for providing services to the victims, medical and psychological support, counseling, legal aid, and financial aid. The government will also like to maintain an online register of offenders with details of the offenders. It will be linked to the National Registry of Sexual Offenders. This way, the register offenders can be put under additional restrictions. Many countries have made such registers as publicly accessible. The second proposed Shakti Bill seeks to amend the existing provisions under the Criminal Procedure Code (CRPC) and the Indian Penal Code (IPC) and the Protection of Children from Sexual Offences Act. A sum of Rs 10 lakh will be given to the victims and the amount will be collected from the offenders as fine. The time for appeal has also been brought down from 6 months to 45 days. The bill proposes crimes which include threatening women and defaming them on social media and making false complaints about rape and acid attacks, non-cooperation of social media platforms and public representatives in such investigation, and bringing in restrictions to protect the identity of victims in molestation cases and acid attacks, just like in rape cases. It will change and enhance punishments, which will include death penalty for rape, fine up to Rs 10 lakh on perpetrators of violence, faster investigation and quicker disposal of cases. The changes are proposed in existing sections of rape, sexual harassment, acid attack, and child sexual abuse. The bill proposes death penalty in cases of rape, gang rape, rape by persons in authority, aggravated sexual assault of minors, and in cases of acid attack when grievous injury is caused. The proposed Shakti Bill has its shortcomings as well. Many organizations as well as human rights activists, lawyers have submitted an open letter to the Chief Minister of Maharashtra writing against the implementation of Shakti Bill 2020. The letter signatories also included famous Advocate Indra Jaising, Advocate Veena Gowda, Advocate Maharuk Edenwala, and Advocate Susan Abraham. Organizations working in the field of gender justice such as Democracy Collective, Feminist Collective, and Forum Against Oppression of Women have also supported the letter. The letter to the Chief Minister stated the amendment, which seeks to add explanation to Section 375, rape, of the Indian Penal Code, where parties are adults and the conduct of such parties from all circumstances surrounding the same appears that there was consent or implied consent, or a presumption of consent will be made, negates the entire definition of consent under Section 375 and the offence of rape itself. This is a step back from the 2013 amendments in the Verma Committee report, where the definition of consent was added. The proposed enhancement in the punishment for rape, gang rape, sections 376, 376D, 376DA, 376DB and 376E, and penetrated sexual assault against children, that is section 4 and 6 of the POCSO Act, to include death penalty will be counterproductive to women and contrary to the statement and object of the law. It is the certainty of the investigation, trial and punishment that works as a deterrent rather than the severity of the punishment. Studies have shown that more than half of the total offences under the POCSO Act are committed by persons known to the children. In such cases, the possibility of the accused person being awarded the death sentence multiplies the conflict and the trauma faced by the victims, and is most likely to prevent the reporting of such crimes. Now we are going to discuss the provision that talks about women being punished on the pretext of false case. Section 12 of the Special Courts and Machinery for the Implementation of Shakti Act 2020 punishes filing false complaints or providing false information regarding sexual and other offences against women solely with the intention to humiliate, extort, threaten or defame the accused. We believe that this provision is concerning as it perpetuates the patriarchal notion of viewing women with suspicion as unworthy of being believed and likely to incriminate men in false cases for unscrupulous purpose. Veena Gowda, a senior advocate, was quoted as saying, "The government should focus on making the judicial system work properly. For example, better forensic labs, counseling sessions, and sympathetic medical examinations could be a beginning. But what else can be done? Maybe the solution lies in improving investigations and trial processes instead of just speeding up the process. The undue delays which end up in the mental harassment of the victims can be avoided by the institutions. The government can provide counseling and support to the victims so that they could come and testify in court without being harassed. Government should introduce proper classes for sex education starting from adolescence age. Students from an early age should be made aware about sex, consent, sexuality. Courses related to gender studies, gender sensitizations should be included as mandatory subjects. The government should endorse ad campaigns for social awareness regarding sex education, HIV, AIDS, STDs, consent, and crimes against women and children. Victims should be assured of their rights. They should be provided with the safety and security and mental and physical support. Victims don't get an opportunity to say and represent herself or through a family member what her life and trauma has been. What do you think about this new law? Do you think its implementation will bring any change or things will remain the same? Let us know in the comment section, and please like, share and subscribe to our channel if you like today's video.
Like, share and subscribe to our YouTube channel. Hit the bell icon to never miss an update.